We have three cases before the docket today. The first case is, I believe, Farrell versus Rivera Auto Transport LLC, Tobin Motor Company, and other parties. Is the appellant ready to proceed?
Well, yes, Your Honor. We filed an emergency motion this afternoon. We reached a settlement at a little after 12 noon today. I think both Mr. Brownlee and I believe it would be not advantageous to have the argument. Best for our clients not to know how the court may feel about the case. We think if we could probably have the settlement wrapped up in the next 30 days. And so would request that...
Well, that's your choice if you want to present argument, counsel. We have not canceled oral argument, nor have we ruled on the motion, nor are we required to rule on the motion or to grant it, as you, I know, under Pino versus Bank of New York.
Well, that's
So
why
it's
I'm...
totally, excuse me,
I'm sorry.
that's totally within the court's discretion as to whether to grant the motion or not. This court recently issued an opinion where we declined to grant a somewhat similar motion. So it's totally up to you and your ethical decision as to whether to present argument in favor of your client.
I think Mr. Brownlee and I would both decide not to present oral argument and would, I guess I'll orally move, since I haven't had time. We've been working on the settlement this morning, that the court stay the proceedings for 30 days because part of the settlement requires my client to dismiss this appeal with prejudice.
Well, I've been here 20 years. I never had an oral motion to stay. That motion, as far as I'm concerned, is denied. So you may present argument on behalf of your client if you so choose, or you may choose not to present argument. That would be most unusual, in my opinion, to not present argument for your client in an oral argument that's been scheduled for some time. I understand that parties can settle cases even at the last minute, although apparently this case is not even settled.
It is settled, Your
Excuse me. Excuse me. Since you're asking for a 30-day delay, it apparently isn't settled. So, again, without belaboring the point, since apparently you've decided not to present argument, I would just, again, this is not a reprimand, it's not a criticism, but when a court grants oral argument, it invests significant resources in the case and preparing for the case, and a last-minute decision to settle the case, very understandable, especially in a case involving such serious injuries as occurred here. Certainly understand that. However, the motion has not been ruled on.
Okay.
But again, that's your decision, and I understand your responsibilities.
Right. I guess the case has settled, Your Honor. I was just asking that we keep the case open for 30 days, which I think is customary. Certainly have had that happen in other courts, but I choose not to present oral argument.
Thank you, Counsel. Counsel Rapley, you may proceed.
Your Honor, I'm going to take the same route as Mr. Gowdy and decline to present oral argument. And apologies to the court. We tried everything in our power to get this done sooner.
I understand. No apologies are necessary.
Okay.
But do understand that a motion to delay a case where oral argument has been granted for 30 days may not be granted.
Understood.
So the case may either be dismissed today, or we will proceed to the merits of the case without oral argument.
Understood. Thank you, Your Honor.
Thank you. We'll proceed to the next case.